Welcome. In this video, I'm going to talk to you about the key sections of the Georgia Association of Realtors, or GAR forms, exclusive seller brokerage engagement agreement. This is going to help you understand what you're signing before you make your commitment to getting your house sold with a broker. Let's go ahead and get started. Section 1, exclusive seller brokerage engagement agreement. This section confirms that you as a seller are hiring a real estate broker to exclusively represent you in listing and selling your property. It also states that both you and the broker agree to the terms that are outlined in this document. The property details, including the address and the tax parcel ID, are going to be listed in this section. The legal description will be detailed in this section as well. List price and listing period. This section establishes the price at which the property is going to be listed for sale. It also defines the official start and end dates of the listing agreement. The listing period refers to the duration that the agreement is going to remain in effect. Section 3, marketing. Here, the broker agrees to list your property in the multiple listing service, or the MLS, of which the brokerage is a member of, and also agrees to market your property to potential buyers. The date when marketing officially begins will be specified, and it can be adjusted within a certain time frame if it's necessary. Section 4, compensation to brokers. This section explains how the broker will be paid for their services. Generally, compensation to brokers is negotiable and is not something that's set by law. In this section is where we document how much the broker and the seller have agreed upon that the compensation shall be. You will also decide whether to offer compensation to a buyer's broker and under what conditions that will be. If you lease the property instead of selling it, additional compensation terms will be outlined. Section 5, the protected period. The protected period outlines the period in which the broker will be entitled to compensation under certain circumstances, where this agreement has been unilaterally terminated by the seller or it has expired. Section 6, agency and brokerage. This section outlines the types of agency relationships the broker offers. If the broker allows dual agency representing both buyer and seller, you must confirm whether you consent to this agreement or not. Section 7, lead-based paint disclosure. Federal law requires sellers of homes built before 1978 to disclose any known presence of lead-based paint. You'll indicate whether this applies to your property, and if so, you're going to need to provide a signed disclosure form. Section 8, special circumstances requiring third-party approval. If you need approval from a court or lender before listing or selling the property, such as in cases of bankruptcy, divorce, or short sale, those details will be noted here. Section 9, negotiations. This final section asks whether you authorize your broker to assist in negotiating terms and filling out contract forms in your behalf. Exclusive seller brokerage engagement agreement. This means the seller is officially hiring the broker to list and sell the property. The seller confirms that they have the right to do so and aren't under any other legal agreements. If they were, they might owe money to their previous broker. Section 2, list price and listing period. The seller sets a price for the property, but if it doesn't sell, it might mean that the price is too high. If the home is under contract, but the listing expires before closing, the agreement extends until closing. If a sale contract falls through, the broker can extend the listing period for the time the property was under contract, as long as they notify the seller in writing. Marketing. The broker has full control over marketing the property using signs, flyers, websites, and more. The seller cannot market the home themselves. Photos and marketing materials that are created by the broker belong to the broker unless the seller has paid for them. The seller must ensure that any information that they provide to the broker is accurate. Otherwise, you as the seller could be held responsible. You as the seller should always remove personal items that you do not want photographed. The broker is not responsible for others taking photos or videos of the home. The listing will be added to the MLS, allowing all participating agents to access and share the property details. If you as a seller are on the do not call list, you are agreeing the broker and its agents can contact you. Lockboxes may be used for showings, and even though it's rare, burglaries have happened, so sellers are advised to make sure that you store your valuables securely. Section 4, compensation for the broker. The seller must pay the broker's commission if the property sells. even if the closing happens after the listing period ends. The seller is not required to pay a commission to the buyer's real estate broker. Nevertheless, a seller has the option to offer an incentive or compensation if he or she desires to do so. If the property is leased instead of being sold, the seller must still pay the broker a leasing fee in addition to any sales commission. Protected period. If the seller unilaterally cancels this agreement early without the consent of the listing broker, then the protected period comes into play. The seller will likely owe commission to the broker if the property sells soon thereafter. If the listing is terminated by mutual agreement, then the protected period shall not apply. If the listing agreement naturally expires, as in it was not ended by unilateral termination by the seller, and the seller hires a new listing broker, then the protected period shall not apply and the seller will not owe the original broker anything. Section 6, Agency and Brokerage. The broker can represent sellers, buyers, landlords, and tenants. If the broker represents both the seller and the buyer, this is called dual agency. In dual agency, the broker must remain neutral and cannot reveal confidential information to either party. If the broker assigns different agents to represent the buyer and seller separately, this is what's called designated agency. Lead-based paint disclosure. If the home was built before 1978, federal law requires the seller to disclose any known lead-based paint hazard. The seller must provide records of past inspections and allow the buyer up to 10 days to conduct their own inspection. Section 8, Special Circumstances. If a third party must approve the sale, the seller is responsible for ensuring that this happens. The broker must keep any seller-requested information confidential unless required by law, and the broker cannot give false information even if it conflicts with confidentiality rules. Section 9, Negotiation. The broker can help the seller negotiate a sale, but all final decisions about price and terms are up to the seller. Seller's property disclosure. Georgia law requires sellers to disclose known latent defects, even if it's being sold as is. The seller must provide a disclosure statement within 3 days of the agreement and update it if conditions change. Hazardous conditions on property. The broker is not responsible for inspecting the property. The seller must keep the property safe and warn prospective buyers of hidden dangers. The seller indemnifies the broker against injury claims. Limits on broker's authority and responsibility. The broker is not responsible for property inspections, surveys, appraisals, legal or financial reviews, or monitoring repairs. The broker makes legally required disclosures but does not ensure that the seller complies with contract deadlines. The seller indemnifies the broker against losses due to inaccurate information, undisclosed defects, injuries on the property, and theft during showings. Broker's liability limits. The broker's liability is limited to the commission earned or $100 if no commission is paid. The broker is not responsible for wire fraud losses beyond $100. Section 5, Fraud, Prevention, and Reporting. The broker may report suspicious or fraudulent activities to authorities, lenders, or insurers. You as the seller acknowledge that the broker and its agents do not have special expertise with respect to detecting fraud in real estate transactions. Therefore, you acknowledge that activities which are fraudulent or illegal may be undetected by the broker and its agents. And activities which are lawful and or routine may be reported by a broker as being suspicious, unusual, or potentially illegal or fraudulent. Miscellaneous provisions. Arbitration. Disputes must be resolved through arbitration except for earnest money and broker compensation disputes. Assignability. The broker may transfer this agreement to another brokerage. Attorney's fees. The prevailing party in a legal dispute is entitled to attorney's fees. Fair housing compliance. The seller and broker must follow fair housing laws. FIRPTA, also known as the Foreign Investment in Real Property Tax Act. The seller must disclose if they are a foreign person per tax law. GAR forms disclaimer. The broker is not responsible for ensuring GAR form provisions are upheld by court. Governing law. The agreement is governed by Georgia law. Independent contractor status. The broker is an independent contractor, not an employee of the seller. No imputed knowledge. The broker and their agents are not presumed to know what each other knows about the property. Notices between seller and broker. The seller must remain available for communications and notices must be in writing. Referrals. The broker may refer the seller to third-party service providers and receive compensation. Statute of limitations. Claims against the broker must be filed within 1 year. Survival clause. Certain broker protections, such as indemnification, liability limits, remain in effect after agreement termination. Third-party vendors. The broker may recommend service providers, but this does not mean that they are guaranteeing their work. Broker and seller duties. The broker's duties to the seller are to promote the seller's interest by seeking an acceptable sale price and terms, to present all offers to and from the seller in a timely manner, to disclose material facts known to the broker about the transaction, advise the seller to obtain expert advice on matters beyond the broker's or its agent's expertise, properly account for all monies and property related to the sale. Broker's duties to the seller are as follows: to promote the seller's interest by seeking an acceptable sale price and terms, to present all offers to and from the seller in a timely manner, to disclose material facts known to the broker about the transaction, advise the seller to obtain expert advice on matters beyond the broker's expertise, and to properly account for all monies and property related to the sale. In regards to confidentiality, the broker must keep the seller's information confidential unless authorized by the seller or required by law. Internal disclosures among the broker's affiliated licensees are not considered a breach of confidentiality. The following are the seller's duties: to cooperate with the broker and its agents in selling the property and refer all inquiries to the broker or its agents, to make the property available for showings at reasonable times, to provide accurate property information, including any adverse conditions, to comply with all applicable laws, and to carefully read and comply with contract terms and deadlines. Seller default. The seller shall be in breach of this agreement if the seller unilaterally terminates this agreement before expiration without the broker's written consent, by defaulting on a sales contract, causing it not to close, by agreeing to cancel a contract with a buyer without the broker's consent, by refusing to accept a lawful, bona fide, all-cash offer that meets all listing terms with some exceptions for multiple offers. Broker remedies for default. Seller must pay the broker's compensation immediately for any default except for early termination, which is subject to the protected period terms. Broker remedies for default. The seller will need to pay the broker's compensation right away for any default, except when there's an early termination, which is subject to the protected period terms. The seller will need to reimburse the broker for marketing expenses, advertising, and MLS listing removal fees. And the seller's payment of these costs does not waive the broker's right to claim any additional compensation or damages. Warning to buyers and sellers: beware of cyber fraud. Real estate transactions are increasingly targeted by fraudulent emails impersonating legitimate parties. Criminals do send fake wiring instructions to mislead buyers and sellers into transferring funds to fraudulent accounts. Buyers and sellers need to carefully verify all wiring instructions independently by calling the company to a phone number that you yourself, as the buyer or seller, have looked up. Be cautious of emails that are directing you to send funds to accounts that are outside of the state of Georgia. And beware of slightly altered email addresses mimicking legitimate senders. Section 10, brochures. The brochures that are referenced below are prepared courtesy of the Georgia Association of Realtors. The recommendations contained here are general in nature and may not be applicable to the transaction reflected in this agreement. and are not intended to either be exhaustive or specific advice that the seller should rely on without the seller first consulting with independent experts and professionals of seller's own choosing to ensure that the seller is protected. Section 10, brochures. The brochures provided by the Georgia Association of Realtors contains general recommendations and are not intended to be exhaustive or replace professional advice. The seller is encouraged to consult independent experts for specific guidance. The seller acknowledges receipt by checking applicable boxes, exhibits, and addenda. Any attached exhibits or addenda become part of the agreement and will override conflicting provisions. We've reached the end of this document. This therefore concludes the summary of the Georgia Association of Realtors exclusive seller brokerage engagement agreement form. If you found this information useful, please make sure to subscribe and hit the notification bell so that you'll be informed when we upload our next video. See you next time.